Cool. Okay. Okay. So I know that students are entering, but anyway, we can start. And I would like to welcome you to the third meeting. I think there is a problem with Laura.
Yes, good afternoon, everybody. We'd like to welcome you to the third day of the advanced course, advanced training. Thank you very much for joining us. As you know, the lesson today will be the development of international humanitarian law and the protection of children under international humanitarian law. We are very honored to have with us three experts in this sector. First, Professor Francesca Capone. Professor Capone is Associate Professor of International Law at Scuola Superiore Sant'Anna, Pisa in Italy. She as an expert in the field of children, she has extensively researched on the matter. She's also visiting fellow and guest lectures at several academic institutions across Europe and beyond, including Leiden University, the Max Planck Institute for Comparative Public Law and International Law, and Addis Ababa University. She has undertaken research on a wide range of topics, and in particular, she has extensively written on children's rights and protection of vulnerable groups. And today she will be teaching about the third and fourth Geneva Convention. After, we will have the pleasure to host Ambassador Gianluigi Mastrandea Bonaviri, first Secretary of Italian Embassy in Egypt. Gianluigi Mastrandea Bonaviri is an Italian diplomat. He is Deputy Head of Human Rights and International Human Law Office of Italian Ministry of Foreign Affairs and International Cooperation between 2016 and 2020. He was Italian delegate to several conferences, and he is an expert of international humanitarian law. And he will be addressing the issue of international and non-international armed conflict, the modern conflicts and their challenges. And lastly, we will have the pleasure to have with us Professor Ahmed Aubais Al-Fatlawi, Professor of International Criminal Law at University of Kufa, Iraq. And we will teach about the additional protocols of 1977. So it was a long introduction, and with pleasure that I give the floor first to Professor Capone. Professor Capone, you have the floor. Thank you very much.
Thank you so much. Good afternoon. It is a pleasure to be here, and I'm extremely grateful to the University Network on Children and Armed Conflict for inviting me to take part in this course. And also, I'm very thrilled to have been introduced by Ms. Paolina Massidda. It is a true honor. Thank you so much for your kind words of introduction. So without further ado, I will start by sharing my very messy screen, and I hope you can forgive me, but it is towards the end of the academic year, so I have basically a little bit of everything here. Here we go. So as anticipated by Ms. Massidda, today's lecture is going to focus in particular on two of the four Geneva Conventions of 1949. Geneva Convention number 3 and Geneva Convention number 4. Before we start, I would like to explain a little bit to you which are the topics that I would like to cover, and also which are the learning objectives that I have set. So first of all, we will discuss what are the Geneva Conventions and why are they still so relevant, considering the fact that they have been negotiated and then adopted many years ago, and that, of course, the rules of war and the methods of war have, in the meantime, evolved a lot. So the learning objective that we associate with this topic is to grasp an understanding of the main features of the 3rd and 4th Geneva Conventions. The second topic that I'm going to cover is which are exactly the provisions that actually protect the rights of children and that are enshrined in the Geneva Conventions 3 and 4, and what exactly do they tell us about the extent to which international humanitarian law is interested in providing additional protection and promotion of children's rights. The third topic is about how do the Geneva Conventions play a role in relation to the actual protection of children in armed conflict. And in relation to this specific topic, the learning objective that I have set is to understand and reflect a little bit better on the interplay between IHL and other fields. I'm not going to delve into international criminal law because, of course, we are going to have several sessions concerning how international criminal law is dealing with violations of international humanitarian law that affect, in particular, or if not exclusively, children. But the point that I would like to raise towards the end of this session is mainly how IHL is relevant for the UN architecture on children in armed conflict, and in particular, how it relates to the monitoring and reporting mechanism that has been set up by the UN Security Council in 2005. So this is the outline of the session. The first point is exactly to provide a short overview of IHL, but limited, of course, considering the fact that you are going to talk about the difference between international armed conflict and non-international armed conflict as soon as we finish this first part of the session. And then you are going to delve also into the issue of the protection afforded by the additional Protocol 1 and 2. So the second point is going to be children's rights under the IHL framework with particular relevant reference to the provisions that are enshrined under the Geneva Convention 3 and 4. And finally, how these conventions actually fit within the United Nations architecture on children and armed conflict. So before we start, I think that since this is the first session on international humanitarian law, it is important to draw the line between some key concepts. And the first one is to define what is the law of armed conflict, also understood nowadays as international humanitarian law. So we are talking about the body of international law, international public law, that regulates the behavior of the parties that are involved in an armed conflict. So we talk mainly about jus in bello. What the law of armed conflict or international humanitarian law is not, is the body of international law that regulates instead when it is lawful to be involved in an armed conflict. So when it is possible for a state to wage war against another state or to resort to armed force against another actor on the international plane. And this goes under the name of jus ad bellum. These two ambits shall be kept separate, even though also amongst experts, it is not sometimes so easy to actually draw a distinctive line between the concepts and the implications that are attached to each of them. So we do have exceptions in relation to when it is possible to actually resort to the use of force between states, which, by the way, is forbidden by Article 2.4 of the United Nations Charter. And those exceptions are mainly three. The consent of the state. So, for example, if a state asked for the military support of another state in countering a rebellion or a non-state armed group trying to take power in its territory. The acts that are taken in self-defense under the UN Charter, and in particular Article 51, which disciplines both individual and collective self-defense. And finally, if there is an authorization to that end issued by the UN Security Council under Article 42 of the UN Charter. Why am I focusing on this issue that seems quite trivial for those of you that already have a little bit of understanding of the general rules that govern armed conflict? I'm saying this because if we look also at the headlines of the newspapers and more generally at the news broadcast today, we will see that since the inception of the armed conflict between Russia and Ukraine, there has been a lot of confusion and overlaps between the two different regimes that govern the situation. On the one hand, the prohibition on the use of force, and on the other hand, the way that the behavior of the parties shall be regulated and disciplined in the context of an armed conflict. So if we want to summarize what it is international humanitarian law and why it is relevant, we can say that first of all, we are dealing with a branch of public international law. Then we can specify that this branch of public international law is actually focusing on how the relations between states must be governed in the occurrence of an armed conflict. But, and this is important, the regulations find application also to fighting within the state. So to armed conflicts that are of a non-international character, that are fought between a non-armed state, a non-state armed group and a state, or between two or more non-state armed groups within the territory of a state. Then we also have to keep in mind that IHL is designed and drafted on one specific purpose, which is to reduce as much as possible the suffering and the damages that are caused by war. And finally, we have to remember that when we talk about IHL, we talk about rules that need to be implemented by actual persons, so the parties that are involved into the armed conflict. So the regulations and the norms are addressed in particular to the members of the parties involved in the war. And finally, we also have to remember that IHL is not designed to impede military efficiency, but on the contrary, it is designed and created to strive a very difficult balance between the possibility to carry out military activities and the need to protect the persons that are not involved in those activities or no longer involved in those activities, that needs to be shielded by the harmful effects of armed conflict. The main sources of IHL can be summarized looking in particular at two different bodies of norms. On the one hand, we have the Hague Law, which is a corpus of instruments that have been drafted and designed to actually regulate the actual conduct of armed hostilities. So they mainly focus on which are the methods and the means of warfare that are tolerated and that can be implemented by the parties involved in an armed conflict. On the other hand, we have the so-called Geneva Law, which pertains to the rules that protect the persons that are no longer taking part in the hostilities or that were from the beginning not involved in the hostilities. We have to descend the 4 Geneva Conventions that, as we know, have been adopted in 1949, so quite a long time ago now. And the first one is concerned with the wounded and sick soldiers on land. The second is concerned with wounded and sick soldiers on sea. The third is concerned with the prisoners of war. And the fourth with the protection of civilians and the occupation. We also have traditional protocols that have basically broadened the scope of the Geneva Conventions to some extent, and in particular for the purposes of our presentation and session, because it is through the additional protocols, as we'll see later on, that the recognition of the importance to award and offer additional protection to children has been incorporated into a legal instrument of international humanitarian law. So the additional protocols play a very prominent role within the domain of the IHL framework that protects children's rights in armed conflict. But as we said, the focus of this first session is going to be mainly on the prisoners of war, so the third Geneva Convention, and on the protection of civilians in situation of armed conflict and in situation of occupation, which is governed by the Geneva Convention number 4. Also, we have to keep in mind that amongst the sources of international law that find application in the context of an armed conflict, we also have in customary international law, which is an absolutely fundamental source of public international law, as stated by Article 38 of the International Court of Justice Statute, according to which the court is called to apply, between other sources, also international custom as evidence of a general practice accepted as law. And in the field of international humanitarian law, the role that is played by customary international law is very important. In 2005, the International Committee of the Red Cross has concluded a very important study on international humanitarian law that resulted in 2 volumes. The first one enshrines the 161 rules that basically govern international humanitarian law, encompassing both international armed conflict and non-international armed conflict, and that are of a customary international law character. And in particular, for our purposes, it is important to make reference to Rule 135, which concerns children affected by armed conflict, which are entitled to special respect and protection. So these rules that have been crystallized throughout this study of the International Committee of the Red Cross are extremely important, because they also help us to actually bridge the gap between the 2 sets of norms that govern, on the one hand, international armed conflict, and that, as you will see later on during this panel, is actually a more substantial body of norms and regulations. And on the other hand, the set of norms that governs non-international armed conflict, which is much more limited and that needs the resort to customary international law to be not only expanded, but also properly implemented at the domestic level, but also at the international level, whenever the judges, for example, of the ICC have the opportunity to actually apply IHL to a given case. There are some fundamental dichotomies that basically characterize international humanitarian law. The first one is the distinction between international versus non-international armed conflicts that you are going to deal with in a minute, or well, after my presentation for sure. And then the second distinction, which is at the essence, at the core of IHL, and that is also very relevant for our purposes, is the distinction between combatants or fighters versus non-combatants and civilians. So as you probably know, this distinction, which in principle at least should be really clear-cut and well-defined, sometimes gets a little bit blurry. And this is a problem, especially when we talk about non-international armed conflicts, and especially when we talk about the involvement of children in the ranks of non-state armed groups. The other dichotomy that characterizes international humanitarian law is for sure the distinction between military objects versus civilian objects. So who is a legitimate target under the law of armed conflict? Who can be legitimately attacked? Who can be lawfully killed even under IHL? And who instead is particularly protected and cannot be the legitimate target of any form of attack? So I will skip the distinction between international and non-international armed conflicts because you're going to delve into that very soon. Whereas with regard to the distinction between combatants, fighters versus non-combatants and civilians, I think it's important that I spend a couple of words extra due to the fact that these resonates also into the application and the scope of application of the Geneva Conventions, both the third that deals with prisoner of war and the fourth which deals with the protection of civilians. So before we elaborate on what the Geneva Conventions tell us and which sort of protection they provide in particular to children, we need to distinguish between who is actually a combatant and who is not, who has the combatant status and who has not. So, as you probably know, one of the cardinal principles of international humanitarian law is exactly that, the distinction between who is actually allowed to take up the arms and participate in the fighting, and who instead cannot do that, because if he or she does it, then he or she will lose the special protective status that pertains to the civilian population. So, under IHL, civilians are basically not defined. They are simply described as non-combatants. So everyone who is not combating is, in principle, a civilian. Whereas the category of combatants is definitely a little bit more thought of, a little bit more elaborated throughout the norms that are part of international humanitarian law. So we can distinguish different typologies of people that are actually participating in the hostilities. We have the combatants, which are the members of the armed forces of a state. And together with these armed forces, we can also include the voluntary militia that fulfill certain criteria or are formally incorporated within the armed forces of a state, due, for example, to the existence of a very simple contract between the armed forces and the voluntary corpses that are associated with it. Then we have non-combatants, which is a very limited category, because basically it encompasses the members of the armed forces who are not combatants. And who are these? So basically, those are the medical and religious personnel that accompany the armed forces, are still regarded as members of the armed forces, but are not combatants, which means that, for example, if they are captured, and in principle they shall not be captured, they do not fall within the remit of the prisoner of war status. They can be retained, but also if it is essential that they perform their duties for the prisoners of war. Then we have also another distinction that belongs mainly to the field of non-international armed conflicts, in which we do not have the combatant status. The people that are participating in the hostilities and that are not members of the armed forces do not have the so-called combatant privileges. So they are characterized as irregular fighters, unlawful or unprivileged combatants. And sometimes if they are members of terrorist organizations, due to the fact that this terminology was used very often since the 9/11 attacks onwards, they are sometimes described as unlawful enemy combatants, which does not create a third category between civilians and combatants. It is simply a terminology that has political connotations and that was used by the United States of America and its allies in the aftermath of the 9/11 attacks to justify the so-called war on terror. And then within this category, we also have to include the combatants that are hors de combat, which means the people that belonged to the armed forces of a state, or in any case to the voluntary corpses associated with the armed forces of a state, but that are no longer taking part in the hostilities due to the fact that they fell ill, they have been wounded, or they simply decided that they do not want to fight anymore. So they surrendered themselves. as I said, we need to keep in mind that there is the distinction between civilian and combatants that represents the core of IHL. And this assumption has to be taken into consideration also when we talk about the phenomenon of child soldiers. So there is no distinction, there is no provision in the IHL framework that tells us that a child cannot be regarded as someone who is directly participating in hostilities. We do have, of course, some limitations, some caveats that are mainly framed under Additional Protocol 1 to the Geneva Conventions, and in particular Article 77, which establishes that the parties to an armed conflict of an international character, but the same rule is also replicated in Additional Protocol 2 at Article 4, Paragraph 3, shall not recruit and use children under the age of 15 to directly participate in the hostilities. Of civilians losing their status and becoming, to some extent, unlawful combatants, or in any case, unlawful participants in the armed conflict, is something that is important, is relevant, also with regard to children, either because they are soldiers and therefore they have been enrolled, they have been enlisted by the armed forces of a state, or because they were civilians and they lose their status, they lose their protection because they take up the arms and they decide to directly participate in the hostilities. An important caveat is that the notion of direct participation in hostilities, which is pivotal within the IHL framework, has not been defined in any of the rules that are enshrined in the Geneva Conventions or in the additional protocols. And this is quite surprising, given the fact that, as I stated, this represents the very core of the IHL framework. But a study that was carried out by the ICRC and that was completed in 2009 helped us to actually navigate this very difficult topic of what it really means for a civilian to directly participate in hostilities. So we basically have three cumulative elements that characterize the participation of a civilian that therefore loses his or her status for taking up the arms and joining the fighting. And these three elements are the threshold of harm, so the action that the civilian undertakes must be of enough gravity to cause death or serious injuries to the other party involved in the armed conflict, or at least a relevant military advantage. The other element is the belligerent nexus. This act must be carried out within the context of an armed conflict. And finally, the direct causation. So there must be a direct link between the act and the harm that is caused by said act. So in the report by the International Committee of the Red Cross, which was authored by Niels Melzer, you will see, if you are interested in this topic, that there are a bunch of different examples that explain to us which actions can actually be characterized as direct participation in hostilities and which actions do not fall under the remit of this very important notion. And you will see during the course of this training that the notion of direct participation in hostilities is also of pivotal importance within the caseload of the International Criminal Court. Ever since the Lubanga case onwards, whenever there is an issue that pertains the violation concerning the recruitment and use of child soldiers, you will see that the notion of direct participation in hostilities plays a central role, either because it is interpreted in a broader way, so as to use the word of the court in the Lubanga case. They refer to active participation in hostilities as a concept that is broader than directly participation in hostilities, or because this concept is very important also to criminalize and prosecute intra-parties violence. So the violence that is committed, the violations that are committed by a non-state armed group, for example, towards the child soldiers that are in its ranks. So this concept is extremely important, and it will be with you throughout most part of the training. The other dichotomy that is very important for our purposes is the distinction between military objects and civilian objects. So who can be a target and who cannot be a target. So basically, once again, in this case, civilian objects are described throughout a negative definition. Additional Protocol 1 to the Geneva Convention tells us that everything that is not a military objective shall be regarded as a civilian objective. And Article 52 sheds a little bit of extra light on the issue by saying that military objectives are limited to those objectives that by nature, location, purpose, and use make an effective contribution to military action. This is important because we have to understand that the protection that is granted to civilian objects in armed conflict, like the protection that is granted to civilians in armed conflict, is not set in stone. A civilian can lose his or her protection, and in the same way, a civilian object can lose its protection. So, for example, if a school is used to store weapons, then it becomes a military target that can be lawfully attacked. The issue is that there must be always a presumption that in case of doubt, and if the fog war does not allow to understand exactly if an object is civilian or military, the presumption should always be in favor of the civilian status of said object. With these premises in mind, and I'm sorry, I know that it was a lot of information, but I think it was important to set the tone and also to highlight which are the main important aspects that we need to take into consideration before delving into the Geneva Conventions 3 and 4. We need, first of all, to understand what is the Geneva Convention 3 concerned with? So I say that the Geneva Convention 3 is concerned with the issue of prisoners of war. And of course, you can immediately link the notion of prisoners of war to the notion of combatants, because of course, the prisoners of war status is something that is bestowed upon those who are regarded as lawful, legitimate combatants. And therefore, if they are captured by the other party, they do enjoy by law certain privileges, certain, let's say, special treatment that they are entitled to. So prisoners of war may include the members of the armed conflict, of the armed forces, the members of the voluntary corpuses that are associated with the armed forces of a state. They can include also resistance movements, and they can include also the civilians accompanying the armed forces. So, for example, the journalists that accompany an armed force. And the convention, the Geneva Convention number 3, is actually composed of 143 articles that basically lay down which are the main requirements that need to be fulfilled in order for prisoner of war to be treated in a way that is human and adequate. And the provision also established guidelines on labor. So, for example, the prisoners of war can actually perform some work that it's not war-related and can also receive remuneration for said work. And also the criminal trials that they might undergo, not for lawfully participating in hostilities, because we know, since they fall under the remit of combatants, that they actually had the right to participate in the hostilities. But for any other breaches, including serious violations of international humanitarian law that they have committed during the armed conflict, they can be prosecuted and tried. On the other hand, the Geneva Convention 4 deals specifically with the protection of civilian persons in time of war and also in time of occupation. This convention has been adopted right in the wake of the Second World War, and this is the most humanitarian amongst the international humanitarian law instruments and documents. Why is that? Because it was adopted basically keeping in mind the disruption and the suffering that the Second World War has caused to the civilian population. And Article 4, paragraph 1st of the 4th Geneva Convention helps us out to understand who are the persons that are protected under the convention itself. And so basically we speak about those civilians mainly who at a given moment or in any manner whatsoever find themselves in case of conflict or occupation in the hands of a party to the conflict or occupying power of which they are not nationals. And those provisions that are enshrined in the 4th Geneva Conventions are actually quite detailed to the extent to which they offer specific protection to the protected persons. And in fact, we are talking about a convention that enshrines 159 different articles. If we want to link it to the situation of children as protected persons and as part of the civilian population that falls under the remit of the 4th Geneva Conventions, but also to some extent of the 3rd, we need to make perhaps a couple of preliminary considerations. So first of all, we have to understand that under the international humanitarian legal framework, there is no definition of who is a child. So if we look at the conventions and the additional protocols, we will see that in most documents, there is a reference to the age of 15 years, which sets the line, let's say, below which children should be in principle afforded special protection. That is not always the case. We also have some provisions, like, for example, Article 68 of the 4th Geneva Convention, which basically regard as minors everyone under the age of 18. This represents an important gap because, as you know, under the human rights framework, on the other hand, there is the tendency to adopt as much as possible a straight 18 approach, meaning that we regard as children everyone under the age of 18 years old, because this is the reference that is spelled out and enshrined in Article 1 of the CRC, the Convention on the Rights of the Child. So we can say that there is no alignment in this regard between the IHL framework and the international human rights legal framework on the other hand. Whereas instead, if we look at the Rome Statute, we will see that the International Criminal Court does not exercise jurisdiction over anyone who is under the age of 18 years old. So it is more aligned towards the international human rights legal framework for sure. Another thing that we have to keep in mind is the fact that the Geneva Conventions do not regulate the participation of children in hostilities, and that specific legal development, which is absolutely important for our purposes, has been achieved only through the adoption of Additional Protocol 1 and the already mentioned Article 77, that then is reabsorbed or transposed also in Additional Protocol 2 through Article 4, paragraph 3. And finally, we also have to keep in mind that the Convention on the Rights of the Child, the CRC, finds application also in armed conflict. So the protection that is bestowed to children through the CRC itself does not cease just because there is an armed conflict taking place. And in fact, we have express references to armed conflict in the text of the convention itself, and in particular in Article 38, that disciplines the recruitment and use of children in hostilities, and Article 39, which instead deals with children's reintegration in the aftermath of any sort of violations, including armed conflict. So, looking a little bit more closely at what the third Geneva Convention tells us with regard to children, or in any case, how the Geneva Convention number 3 has been interpreted throughout the years in order to accommodate also special protection for children, we can say that with regard to children between the age of 15 and 18, if they are enrolled in the armed forces of a state, they do have combatant status and are ipso facto regarded as prisoners of war if they are captured. Children under 15 years of age who, notwithstanding the prohibition to recruit and use children in hostilities that is enshrined in Additional Protocol 1 and also Additional Protocol 2, are still recruited or used in the armed forces, in this case, they will still have combatant status, and if captured, they will still have prisoner of war status. But we have to keep in mind that they also have an entitlement to special protection if they are captured and if they are regarded as prisoner of war. That comes from the additional protection, the special treatment that is granted to them by Additional Protocol 1. Also, there is basically no age limit for the entitlement to the prisoner of war status, meaning that everyone could actually be regarded as a combatant and therefore enjoy the prisoner of war status. But what we have to keep in mind is that a child under the age of 15 years old that has been regarded as a combatant and is in the end of the enemy and therefore is entitled to prisoner of war status cannot be prosecuted, put to trial for taking up the arms and participating in hostilities. Why is that? That is because the formulation of Article 77 of Additional Protocol 1 clearly states that it is the duty, the obligation of the parties involved in the international armed conflict not to recruit or use children under the age of 15. So the child that has been recruited and has been used to participate in hostilities bear no responsibility for that, and he cannot be prosecuted only on the grounds that he has participated in the hostilities even though he or she was underage. With regard to the Geneva Convention 4, it is important to say that it is, as I explained at the beginning, the most focused convention on the protection of civilians and therefore on the protection of children. And there are 17 different provisions and articles that deal specifically with the protection, the additional protection that is offered to minors that find themselves in the midst of an armed conflict of an international character, because we know that the Geneva Convention number 4 applies, like all the other Geneva Conventions, only in situations of international armed conflict, or in situation of occupation, because the 4th Geneva Convention disciplines and governs also that situation. So we have specific provisions that protect children in armed conflict in different situations, or even better, with regard to different aspects. For example, we have articles that discipline the evacuation of children, which can take place only in accordance with specific security precautions, and also the setup of special zones, which are disciplined by several articles enshrined in the Geneva Convention number 4. Then we also have specific provisions that regard the assistance and care that is provided to children in international armed conflict according to the 4th Geneva Convention. In particular, Article 24, for example, enshrines the right that children have to the protection of their cultural environment, their education, and the exercise of their religion. Then we also have specific provisions that deal with another very important topic, which is the identification of children, the family reunification, and the status of unaccompanied children. All these issues are disciplined by several provisions that are enshrined in the 4th Geneva Convention. And then we have specific provisions dealing with the education and the cultural environment that, of course, pertains to both situation of international conflict and situation of occupation. So there are a number of obligations on the side of the occupying power, which includes also access to education for the children that live in the occupied territories. And then there are special provisions that concern the arrest, detainment, or internment of children, which, as you can imagine, are particularly thorny and complicated issues. So, for example, with regard to the specific provisions, we can say that if children are held in detention, the detaining power must ensure that, first of all, they are lodged with their family members in the same place of internment, then that they are given additional food in accordance with their physical and psychological needs. And also, they must be allowed to attend school, even inside or outside the internment facility. And also, if there is the releasement at the end of the hostility, they shall be given priority. And finally, another important provision is the already mentioned Article 68 of Additional Protocol 4 that deals with the exemption from death penalty. And in this case, it's interesting to see that Article 68 makes reference not to the age limit of 15 years old, but rather to the age limit of 18 years old. Moving towards the end of the presentation, I also think that it is important to shed a little bit of light on how this corpus juris that we find in the IHL framework relates to the broader architecture that the UN has established on children and armed conflict to make sure that children have received extra protection in context of international or non-international armed conflict. So as you know, and as you will see in the course of this training program, the United Nations has started to become concerned with the issue of children in armed conflict, starting from 1996 with the report on the impact of armed conflict on children that was authored by Graham Achel. And ever since, there has been a growing trend on the side of the UN Security Council to provide additional protection, additional layers of protection, and to issue more and more focused resolutions to make sure that the rights of children are protected and duly taken into account also in situations of armed conflict. So as you will see in the course of the training, the let's say the peak of these UN architecture on children armed conflict is represented by the establishment of a monitoring and reporting mechanism. I'm not going to talk about it because you will have specific sessions on the topic, but just so you know, there is a strict correlation between the protection that is afforded through the UN mechanism and the provisions that are enshrined under the IHL framework, and in particular, the 3rd and the 4th Geneva Conventions that we have briefly discussed today. So Under the United Nations Architecture on Children and Armed Conflict, we have 6 grave violations of children's rights that have been specifically singled out and that are the object of scrutiny and monitoring by the United Nations. These violations, these 6 violations that you can see represented here, actually match violations of the law of armed conflict. They reflect the existing legal framework that is enshrined in the Geneva Conventions, as well as in the additional protocols, as well as in customary international humanitarian law that I have mentioned at the beginning of my presentation. So, for example, in the case of the recruitment and use of children, we know that it is forbidden under Additional Protocol 1, as well as Additional Protocol 2, and under customary international humanitarian law. The killing and maiming of children is also forbidden, and bearing in mind the distinction between civilians and combatants, we now know that a civilian can never be a legitimate target, and if he or she is killed during a military attack, the party still has to take into account other cardinal principles of international humanitarian law, which are principles of distinction, but also the principle of proportionality. So the amount of collateral damage that is allowed under IHL in order to achieve a military objective. And then we also know that there is special protection afforded in order to prevent children from becoming the victims of sexual violence. The 4th grave violation is attacks against school, and this is also protected already by the 4th Geneva Convention, as well as in the subsequent additional protocols. Abduction of children is also forbidden under IHL, both under the Common Article 3 to the Geneva Convention, and you will see in a minute, this time for real, because I'm heading towards the end, that Common Article 3 is regarded as a mini convention that basically protects the rights of civilians and people no longer taking part in hostilities in the context of non-international armed conflict. So implicitly, it protects also children against abduction. And then denial of humanitarian access. We have plenty of provisions that under the IHL framework forbids the denial of humanitarian access, starting from Article 54 of Additional Protocol 2 that protects the civilian population from starvation, Article 23 of the 4th Geneva Convention that requires the parties to make sure that they provide access to humanitarian assistance in order to reach the civilian population. And in particular, there is a reference to children, pregnant women, and mothers of children under the age of 7 years. So to conclude, which are the take-home points that I would like to highlight? We still need the Geneva Conventions. They still offer protection to children. They have been integrated and broadened through the adoption of the additional protocols, which is a very welcome achievement. There are still some gray areas that need further work, further development. For example, the fact that the age gap, there is an age gap between the human rights legal framework and the international humanitarian legal framework when it comes to the protection of children. And this gap should be overcome by moving together towards a straight 18 approach. Also, another important issue is that the violations committed against children in armed conflict that have been singled out by the United Nations are not framed into a legal vacuum. On the contrary, they very much reflect the provisions and the protection that is already afforded under IHL, and that is nowadays also afforded throughout the incredible work that the International Criminal Court is doing and the application and implementation of the Rome Statute of the ICC. And I will stop here because I'm afraid that we already ran a little late.
So we thank Professoressa Capone for her lecture. which was very interesting. I don't know if there are some questions from the students. If you have questions, please use the chat, or you can also raise your hand and you can speak. So I can give a couple of minutes. They are a bit shy.
Please don't be. And you can also reach out to me via email if you would like any follow-up explanation, if there is any doubt, or if you would like to receive some materials, some reading materials in the aftermath of the session.
Yes, we will anyway upload the slides and all the material on our website. So you can also go on our website or write an email to the professor. Okay, if there are no questions, I thank again Professor. Okay, we have a question on the chat. You can see it, I think, Francesca, if you can read it.
We could think about the normative evolution like a complete normative. You mean that the evolution from a legal perspective is complete and there is no need to move forward, according to me? If that's the question, if I correctly understood your question, I would say that there are still a lot of gray areas that need further development and further work, in particular with regard to the protection of children in armed conflict, and that we in many taking place in the court of law. And I'm thinking, for example, of the Daganda case before the ICC and how intra-party violence against child soldiers has been configured and interpreted by the court, which are not necessarily reflected yet in the legal framework. So to align two different perspectives, on the one hand, the documents and the instruments, and on the other hand, the interpretation of SAGE framework, at some point, I think would be inevitable. So I know that at the ICRC and also the states parties are considering to revise some of the regulations. So I think that the evolution is not complete now yet, but we will definitely witness further changes and further modifications as we proceed. And those modifications, in my opinion, are also strictly dependent on the progress that are made in relation to the international criminal law framework.
Okay, I'm just seeing if there are some
The law applicable to the detainees during non-international armed conflict. Very quickly, the laws that apply to detainees during non-international armed conflicts are the law of the state, because as we said, there is no combatant status that pertains to the people taking up the arms in the context of non-international armed conflict. So in principle, everyone could be tried for participating in the hostilities. The only limitation to that for those countries that have actually ratified additional protocol 2 is based on Article 6, paragraph 5, which says that the states parties agree to grant the broadest possible amnesties to the people participating in the hostilities.
Okay. Thank you so much. Thanks. Okay, I think there are no other questions. So I thank again Francesca Capone.
Thank you so much.
Thank you so much. And we will give the floor to Mr. Gianluigi Mastrandrea Bonaviri, as we said, Italian diplomat and first secretary at the Embassy of Italy in Egypt. Gianluigi, the floor is yours. Thank you.
Hello, can you hear me? Thank you. Good afternoon to everyone. Yes, thank you very much. Just I apologize, but if you don't mind, I put off the video because here in Egypt it's a bit difficult to speak for the connection, so that we are sure that. Okay. So Yes, good afternoon to everyone. It is a pleasure to stay here. And I will speak about international armed conflict, non-international armed conflict, and modern conflict, trying to give like a classification under the international human rights law. Actually, after the war exploded in Ukraine, the situation, as you can imagine, got even more difficult than before, also under a legal point of view. So first of all, broadly speaking, I have to say that armed conflict have become more and more complex over the past years. And so many armed conflicts today do not reflect the traditional concept of international humanitarian law that split armed conflict in only two categories. On the one hand, international armed conflict, and on the other hand, non-international armed conflict. Instead, as I told before, many current armed conflicts, for example, include both an international and non-international element. Or we can, for instance, say that a state can use force against a non-state armed group, but on the territory of another state. Or also we can consider the case of foreign intervention. Foreign intervention can take many forms and many degrees, but of course it is included peacekeeping operation, also peacekeeping operation under the support of the United Nations. Another case, another new case, how to say, we can say is that sometimes in addition to or instead of using its own armed forces, a state may support local armed groups acting on another state's territory. So that is why some experts say that, for instance, that today we can also speak about transnational or extraterritorial armed conflict that cannot be classified under the traditional categories of IHL that, as I said before, are only two, international and non-international armed conflict. But this is also like the case, for instance, of urban warfare, and that maybe we can speak later about urban warfare. That is nowadays one of the most common way to modalities of armed conflict. And broadly speaking, we can say that today and with through the years, today, I think it is very important also the concept of asymmetric armed conflict, or as the major expert in IHL say, asymmetric warfare. So today, quite all the armed conflicts are asymmetric. I mean that they are characterized by disparities, maybe by significant disparities between the military capacity of the belligerent parties. And this asymmetry is a problem for international humanitarian law. It's also a problem under a legal point of view, because this asymmetry often causes that today's armed confrontation cannot respect IHL because they are asymmetric. So to sum up maybe we can say that there is an increasing complexity in armed conflict, and that is putting into question the opportunity, the adequacy of the dual legal framework of IHL, that takes into account only international and non-international armed conflict. And the adequacy of international humanitarian law actually, we can say that is being challenged not only in terms of its ability to encompass a new reality, like I told before, asymmetric warfare, urban warfare, transnational or extraterritorial armed conflict. But another problem, another issue related to IHL is also related to the existence of a strong body of norms and of the applicability of these norms in the case of non-international armed conflict. Because even if, as I told before, IHL recognize obviously also non-international armed conflict, but this kind of conflict is first of all less regulated, because there is, we will see after all the provision, but there are less provision regarding non-international armed conflict. Also, the second protocol to the Geneva Convention that is related to non-international armed conflict nowadays is still not enough ratified, and so there are two problems. The problem to issue, on the one hand, the content of the provision related to non-international armed conflict. On the other hand, also the parties that signed and ratified the second protocol that nowadays are not so many. Even if obviously non-international armed conflict are more numerous than international one, but in the practice, but the law of international armed conflict, the international one, is both, as I said before, quantitatively but also qualitatively more substantial. Why this? Obviously, because states in the international states in the international law, all the treaties that they have made during as years pass by, they never agreed to consider non-internal conflict as object to be subject of international regulation, because they think that the monopoly on the legitimate use of force within the national boundary is strictly inherent in their sovereignty, in their prerogatives. So that is, I think, the major causes of the fact that non-international armed conflict are less regulated, above all under a civilian population point of view, because the protection in non-international armed conflict is not maybe enough, at least a lot of experts say this. So this was, how to say, a short introduction, but of course now we can, under a legal point of view, and then maybe if you want also we can analyze Syria or I don't know, Ukraine. So some cases, but first of all, under a legal point of view, it is important to deal with, on the one hand, international armed conflict, and on the other hand, non-international armed conflict, because all the other kind of modern conflict are not taken into consideration by IHL, but anyway, we will deal again with the new kind of conflict at the end. So to start with international armed conflict, I think that the relevant provision, the most important provision is we have to take into consideration, broadly speaking, the 4 Geneva Convention and the first additional protocol that are the basis of IHL, that contain the most important rules, how to say, limiting the cruelty of war. So the 4 Geneva Convention and the first protocol protect people who do not take part in the fighting, such as civilian, doctors, aid workers, and also those who can no longer fight. So wounded, sick, prisoner of wars, and the Geneva Convention are considered one of humanity's most important accomplishment of the last century, and as I told before, are at the core of international humanitarian law. I don't think it is necessary to repeat the name of the convention, but anyway, the first one is about the condition of the wounded and sick in armed forces in the field, the second at sea, the third one is related to the treatment of prisoner of war, and the fourth, the last one, is related to the protection of civilians. So to qualify the notion, to classify the IAC, International Armed Conflict, what is very important is Article 2, and Article 2 is common to all the 4 Geneva Conventions, so it's an article identical in all the 4 Geneva Convention, and I think that is the central pillar regarding international armed conflict. It is important because, first of all, it establishes the circumstances and the conditions under which the same convention apply. And Article 2 represented a big step forward when the convention was adopted in 1949, because it addressed it like a lack in earlier international humanitarian law, because as you maybe know, the Hague Convention, but also the previous Geneva Convention did not specify under what condition their application would be triggered. So Article 2, common to the 4 Geneva Convention of 1949, is the first provision that at least tries to qualify international armed conflict, even if, as we will say after, it fails in qualifying very well international armed conflict. So to come to the content of Article 2, we have to say that the article states that the convention should apply to all cases of declared war or of any other armed conflict which may arise between 2 or more of the contracting parties, even if the state of war is not recognized by one of them. And this is very important because as was the fact that the Article 2, common to all the Geneva Convention, qualify international armed conflict, not only the declared armed conflict, but only the conflict that are not recognized by the party, so that are not declared as armed conflict. And also in this regard, I think that it is very important to consider also what Jean Pictet said in the commentaries to the 4 Convention, to Article 2, common to the 4 Convention, so that he said that any difference arising between 2 states and therefore leading to the intervention of armed forces is an armed conflict within the meaning of common Article 2, even if one of the parties denies the existence of a state of war. indeed, he says, it makes no difference how long the conflict lasts or how much slaughters takes place. So I have to, in the decades since the adoption of the convention, the duration and the intensity of the armed conflict have not been considered, according to what I said before, as constitutive elements for the existence of an international armed conflict. Nevertheless, recently there was some, it's a minority, but there is also an approach that called into question that hostilities, they say that hostilities must reach, also when we are speaking about international armed conflict, hostilities must reach a certain level of intensity to be qualified as international armed conflict. And but at least under my point of view, I think that the absence of a requirement of a threshold of this condition of intensity and duration for the qualification of international armed conflict should be maintained. So we cannot measure an international armed conflict considering a certain intensity or a certain duration. Because only in this way we can avoid potential legal and also political controversies about whether this threshold has been reached based on the specific fact of a given situation. So, but also the Geneva Academy and RULAC, the official law of armed conflict, says that the threshold for an international armed conflict, if it exists, is very low. So because whenever there is the resort to hostile armed conflict between two states, there is automatically an international armed conflict. And we have also to consider, I think that it is also important to consider the words used by the convention, and in particular by Article 2 common to the fourth convention, because the convention doesn't say war, but they say armed conflict. This can be, I don't know, maybe can be today not an important thing, but at least when the convention were adopted was a very important thing, because armed conflict highlights that the use of the term armed conflict rather than war highlights the fact that the determination whether an armed conflict exists within the meaning of common Article 2 depends on the prevailing circumstances and not on the views of the party to the conflict, or on the intensity or on the duration of the conflict itself. So anyway, while the Article 2 common to the fourth convention define the party to an international armed conflict, use the word armed conflict rather than war, but the same article does not provide, unfortunately, a clear definition of international armed conflict. So during the years, state practices, case law, academic literature tried to develop the legal, how to say, the notion of international armed conflict, moving from Article 2 common to the fourth convention, but there is not obviously just one definition of international armed conflict, because we are dealing with interpretation of Article 2. But I think that it is also important to examine the judgment of the criminal tribunals, in particular TADIC, for the former tribunal of Yugoslavia, that stated in this case that whatever is the definition of an international armed conflict exists whenever there is a resort to armed force between states. So without calling into question the duration, the intensity, and what I told before. Obviously, now there is, how to say, another issue, because if we read very well this sentence, the Tadic case, it says, as I told you now, that there is an armed conflict whenever there is a resort to armed conflict, to armed force between states. But obviously, how to say, it is necessary to establish the statehood of the entities, because we are speaking about states, and international humanitarian law does not deal with this, because both under a legal and a political point of view, the statehood of an entity is regulated, how to say, by international law and not international humanitarian law. So this was just to say that the word is states whenever two or more states use armed forces. Obviously, we have to study, to examine what is states when an entity has statehood, but this is not the task of international humanitarian law, but rather of international law. So just to say another few words about international armed conflict, we have to say that also due to the fact that I told you now, so that Article 2, common to the four convention, it is a very big step forward if compared with the previous regulation, but anyway, has some lacks, and one of these lacks is that, as I told you now, it doesn't define an international armed conflict, but more broadly speaking, Article 2, common to the four convention, was also criticized by some experts that said that it was not very comprehensive and so on. So we have now to take into consideration that some years later, in 1977, the first additional protocol to the fourth Geneva Convention was adopted, and the first international protocols regards international armed conflict. So Article 1 of the first additional protocols to the Geneva Convention tries also to better define what is an international armed conflict, and more broadly speaking, to supplement, to integrate the four Geneva Convention and Article 2 common to the Geneva Convention. So without reading all the text of Article 1 of the first additional protocol to the four Geneva Convention, but maybe it is important at least to highlight some point. First of all, there is a step forward in the sense that according to Article 2, to Article 1 to the first additional protocols, international armed conflict are also conflict between a state and a self-determination movement. So the situation referred in this paragraph include also armed conflict in which people are fighting against colonial domination, alien occupation, against the racist regime, and they are exercising their right of self-determination, such as it is enshrined in the Charter of the United Nations and in the Declaration of Principle of International Law concerning friendly relation and cooperation among states. So this is a step forward in the sense, also coming back to what I was saying before regarding statehood, who say that a state is a state or that an entity is as statehood is not a task of IHL, is not a duty of IHL, but if we see that the first additional protocol to the Geneva Convention explicitly include as international armed conflict the conflict, also self-determination movement. It is obvious that at least under this point of view, the subjectivities of this movement are taken into consideration also by IHL. So this is one, I think, of the most important step forward of Article 1 of the first additional protocol to the Geneva Convention. But I would also like to recall the Martin Clause that was also included in Article 1 of the first additional protocol to the Geneva Convention, that say that in cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and the authority of the principle of international law, derived from established custom, from the principle of humanity, and from the dictates of public conscience. So I think that this is very important. The Martin Clause is very important. Today, a lot of IHL experts are speaking about this clause regarding environment, the protection of environment and landscape during a conflict. But beyond this, I think that it is important under also a general point of view, because how to say it, even if despite the increase in the number of the subjects covered by the law of armed conflict by IHL, and despite the detail of its codification, is not possible, but it is impossible for any codification to be complete at any given moment, at a specific moment. So this clause, the Martin Clause, prevents the assumption that anything that is not explicitly forbidden, explicitly prohibited by, in this case, the first additional protocol, is therefore permitted, because if it is not forbidden, the fact that it is not forbidden, that does not mean that it is permitted, but on the contrary, we have to rely, as the Martin Clause say, to as I said before, to the authority of the principle of international law. So before concluding on this part, international armed conflict, I just want to say that, and also coming back to what I said at the very beginning of this speech, that contemporary, modern and contemporary armed conflict are increasing. They cannot be really qualified as international armed conflict or non-international armed conflict. And in this case, we can mention the case of states that carry out military operation in the territory of another state, but against unknown state armed groups. And anyway, this is what is important in this case to, I think, to know, is that yes, it can be, according to some experts, this can be considered a modern armed conflict. According to some experts, expert, on the other hand, it is under some condition to be should be included. Should be included in the notion of international armed conflict, at least if there is the central issue the central issue here is the consent of the state in whose territory the other states intervene. So if there is the consent of the state, the armed intervention of the third state is, how to say, in some way legitimate, and so we are not in front of any armed conflict because there is the consent of the state. On the other hand, if there is no consent of the state and another state carry out military operation in the territory of these states, even if against a non-state armed group, these automatically become an international armed conflict. So this is just an example to show that also within the biggest category of international armed conflict, more and more there are new classification, new case study, new hypotheses that are not taken in consideration by traditional IHL. So I don't know if you have any question, or we can speak about non-international armed conflict. I have to see the chat.
I think that there is a question here in the chat.
Because I cannot see the chat, yes.
Okay, there is, I can read it so everybody can hear the question. Okay, thank you, sir, for your valuable session. Apart from the known classification of the two types of armed conflict, and in relation to the recent armed conflict between Russia and Ukraine, according to Putin, the Russian president, he called the war as a special military operation. Where does this fall under international humanitarian law? And is the recognition of the status of war essential to label clash as an armed conflict? How this apply to Russian-Ukrainian war, since both didn't declare war status against each others? It's a bit long.
Yes, I don't know if I heard very well, but to sum up is I
regards
think
the conflict between Russia and Ukraine, and where does this fall under international humanitarian law? And yes, and is the recognition of the status of war essential to label clash as an armed conflict?
No, okay, so yes, beyond what the party said, beyond what Russia or Ukraine can say, there is, that I mentioned once maybe before, there is the official rule of armed conflict that already that we can rely on, at least on a legal point of view. So according to the Geneva Academy, to the RULAC, Ukraine today is involved in a series of armed conflicts, not only in one armed conflict, because first of all, according to the official IHL, the official rule of armed conflict, Russia is occupying part of Ukrainian territory since 2014. So when he was there. Second, Ukraine is also involved in a non-international armed conflict in the east of Ukraine. And lastly, the last armed conflict in which Ukraine and Russia are involved is the current one. So if we see the official rule of armed conflict, not not only the current armed conflict is qualified as an international armed conflict. Furthermore, also the International Committee of the Red Cross, in particular, its president went several times both to Russia and to Ukraine that are part of the four Geneva Convention. Both Russia and Ukraine are part of the Geneva Convention and that are part for the, both of the Geneva Convention and the first protocol that I was speaking about before. So in addition to this, they are bound by customary international humanitarian law, and so that is why not only the official rule of armed conflict recognize this conflict as an international armed conflict that is added to other two armed conflicts that I told you before. But also they are part, both Russia and Ukraine, to the legal instrument I was speaking about before. So there was also a very big commitment by the president of the International Committee of the Red Cross that physically went to Russia and to Ukraine. And it was continuously recalling that they are bound to IHL, that it is an international conflict, so that both sides should respect the fourth Geneva Convention and the first additional protocol on the Geneva Convention. In particular, what the International Committee of the Red Cross said several times is that both the parties should ensure the protection, of course, of the civilian population, of the detainees, and the use of weapons with wide area effect should be avoided in populated areas. Also, that critical infrastructure, according to IHL, must be spared, such as we can mention water, gas, electrical system, and so on. And also that space for neutral, impartial, and independent humanitarian action must be protected. So yes, if I understood well the question, under a legal point of view, under an IHL point of view, the current is an international armed conflict, and this also comes back to what I was saying before, that I was speaking about what has been said by Jean Pictet in the commentary of the fourth convention. I was speaking about the Tadic case that says that even if the parties denies the existence of a state of war, this does not mean that a state of war does not exist. And this is what I said before, also in relation to the progress made by Article 2 common to the fourth Geneva Convention, because before the fourth Geneva Convention, the Hague Convention, but also the previous Geneva Convention, spoke only about declared war. That is no more the case, and also it can the situation in Ukraine and Russia maybe also is important related to this situation. It's also important what I said before, that that we don't have maybe to take into account the duration or the intensity of a conflict to qualify it as international armed conflict under Article 2 common to the fourth convention and under Article 1 of the first additional protocol. That is why the official rule, according to RULAC, the situation in Ukraine was quite immediately, now I don't remember the precise day, but was qualified as international armed conflict few days after the war exploded. So they didn't wait to see if there was going to be a big duration, a big violence, or a big intensity. I don't know if I was clear and if I understood the question.
Yes, I think it was clear. I don't know if there is other questions. I think you still have 15 minutes, Gianluigi.
So I don't know how will I do, but I will try. No, yes, we can speak now to about non-international armed conflict. Non-international armed conflict are the pillar, the most important provision regarding non-international armed conflict is Article 3, common to the 4 Geneva Convention. This is a very, very important provision because it marked a real breakthrough, and as it covered for the first time in history a situation of non-international armed conflict. Obviously, this kind of conflict are very different also from each other. They include, I don't know, the traditional civil war, internal conflict that can after spill into another state. So common Article 3 to the 4 Geneva Convention established fundamental rules from which no derogation is permitted. And it is very, some experts define this article to underline to the importance, a convention in miniature, so a mini convention within the convention. So it's like to say that Article 3, common to the 4 Geneva Convention, is like a convention itself. And it sets, it put forward a minimum yardstick, some experts say, that should be respected also during non-international armed conflict. So I don't know to say, it is very long, but I can say that it requires human treatment for all persons in enemy hands without any adverse distinction. It specifically prohibits murder, mutilation, torture, prior and degrading treatment, and so on. So it is a list of some experts also say elementary consideration of humanity that should be respected always in every circumstances, and also during non-international conflict. Said this, we have to say that also, unfortunately, also Article 3, common to the 4 Convention, does not provide a detailed definition of the scope of application of the convention itself, and it does not therefore define what is a non-international armed conflict. It does not contain a definition of non-international armed conflict, like, as I told before, Article 2 does not, common to the 4 Convention, does not contain a definition of international armed conflict. So international armed conflict and non-international armed conflict are not very well defined by the relevant common articles to the convention. So, but anyway, there are some objective criteria that we should examine, we should evaluate in order to see if we can speak about non-international armed conflict. These criteria are better developed in the second additional protocol to the 4 Geneva Convention that is related to non-international armed conflict, and that complement and better details Article 3 common to the Geneva Convention. But here comes also again the problem that the issue that I told you at the beginning, that the second additional protocol is less ratified than the first one. The four Geneva Convention, of course, are universally ratified. On the contrary, the second optional protocol related to non-international armed conflict has a few ratification and also has less provision. So also under a content point of view, it's not so effective like the first additional protocols due to the reason I told you before. So anyway, if we go into the definition, even if, as I told you, is not a real definition, but what does Article 1 of the second additional protocol says? That relating to non-international armed conflict, that this is a conflict that takes place in the territory of an high contracting party between its armed forces and dissident armed forces or other organized armed groups which, under responsible command, exercise such control over a part of its territory. So there are, if we want to sum up, to speak about non-international armed conflict, the condition, there are like four conditions: the responsible command, the control over a part of the territory, and the sustained and concerted character of military operation. The first, the responsible command, we can say that according to the second protocol, there should be the existence of a responsible command in order to speak about internal conflict. That implies, this responsible command implies some degree of organization of the armed group or the dissident armed force. But obviously, this does not necessarily mean that there should be a hierarchical system of military organization similar to that of regular armed forces. But at least, according to Article 1 of the second protocol, there should be some degree of organization, internal organization, I mean, of the armed group in order to speak, in order to qualify the conflict as a non-international armed conflict. Furthermore, the article provides that this armed group should be not only have a responsible command, but must also be able to exercise a control over a part of the territory and to carry out in this part of the territory sustained and concerted military operation. So now I see that I don't have time, but this is there is a lot of literature and a lot of experts that speak about what control over a part of the territory means, because as you know, maybe it is vague, maybe also we have to consider the fact that above all today, in a lot of armed conflict, there is a considerable movement in the theater of hostility. So the territory controlled by an armed non-state actor can change not from one day to another, but can change very fast. So actually, I have to say that some part of the IHL experts say that this criteria maybe should be better defined. And the last criteria, as I told you, is that they have to control, to have control over a part of the territory and to be able to carry out sustained and concerted military operation. So the emphasis is put, therefore, obviously, intensity and on the persistence of military operation. On the contrary of what I said in relation to international armed conflict, where we said that Article 2, common to the fourth convention, that does not require a threshold, does not speak about duration, about intensity. On the contrary, in order to qualify the conflict as non-international armed conflict, this kind of conditions are needed, because the insurgent groups should be able to conduct sustained and concerted military operation also over the time. So the two conditions are continuity and persistence. And I don't just to say that the paragraphs furthermore explicitly excluded situation of internal disturbances and tension from the protocol's field of application. So situation of internal disturbances and tension cannot be considered according to IHL armed conflict. Here there are some issues pending. There is very much literature. On the one hand, the concept of internal disturbances and tensions is not qualified, is not defined by the protocol. But for example, if we see also the position of the International Red Cross Committee, we see that such situation can be large-scale arrests, large number of political prisoners, allegations of disappearance, all these facts that can be considered internal disturbances and tension, but and therefore they cannot be considered armed conflict. Anyway, this because the threshold I was speaking about before is not reached. Anyway, this does not mean that there is no international legal protection applicable to such situation, because they remain covered for sure by universal and regional human rights instruments. Now we don't have the time here to speak about the interplay between international humanitarian law and human rights instruments, but and human rights, broadly speaking. But I just wanted to say that situation of internal disturbances and tension cannot be qualified as internal armed conflict, and therefore are not protected, I have to say, by international humanitarian law, but civilian population as the protection of human rights instrument. There are a lot of new, unfortunately, I see that I am running out of time. I would have a lot of things to say, but it's not possible. But also under and maybe more under an international armed conflict point of view, there are a lot of modern and contemporary armed conflict that are not embraced by international humanitarian law. And above all, we have in this kind of conflict a very big role played by non-armed state actors that today it's very difficult to qualify, to deal with, because they are not state, so they also they don't have the obligation to comply with like Daesh, like a lot of ANSA, and they don't have to comply with international humanitarian law because they are not states. They don't have what I was speaking about before, the statehood. So it is something that also experts of IHL are more and more trying to examine, putting forward innovative solution to make non-state armed actors bound by IHL. Beyond of this, to conclude, there are also, and to come back to my introduction, there are also a lot of new kind of conflict, as all these conflicts are asymmetric, as I told you before. I think that one of the more common new kind of conflict that is not specifically considered by IHL is urban welfare, because today the majority of our conflicts are fought in city. I also dealt with this issue with my collaborator Ahmed Aubais, and we had a big article research about urban welfare, and at the end this research show that urban welfare is really the majority of today non-international armed conflict, but also international armed conflict, and it is something that maybe IHL in some way has to deal with. Timo, I don't know if there is any question. I had a lot of things to say, but I think
yes. I think we are running out of time, but I can't see any question in the chat. I don't know if you have questions. You can use the chat or raise your hands. I can see connected Professor Ahmed Al-Fatlawi. So maybe we can go on. We thank you very much, Gianluigi Mastrandea Bonaviri, for your lecture. If Professor Al-Fatlawi is connected, I can give the floor to you. Professor Al-Fatlawi, Professor of International Criminal Law at the University of Kufa, Iraq. Welcome, Professor Al-Fatlawi, the floor is yours. Thank you.
Hello, Simon. Thank you very much. Nice to see you again. Okay, thank you very much. First of all, my thanks to the organizers of this advanced training course, which reflects an important aspect in developing the skills of lawyers, first in the procedural aspect and specialists in criminal cases, and secondly in the substantive and procedural aspect of accountability for grave violations against children. My special thanks go to Professor Fausto Bocar, Laura, Paulina, Misada, and you, Simona, and other fellow lecturers. My lecture will depends on or will focus on 2 additional protocols of 1977. If we return to the subject of the lecture that will focus on the 2 additional protocols of 1977, we would say that these 2 protocols represent a great effort made by the negotiators and behind them the jurists to fix the gaps described by the 4 Geneva Conventions of 1949. In general, it can be said that the effects of armed conflicts against children decades ago were not as horrible as they are now, due to the breadth of hostilities in contemporary armed conflicts, especially urban warfare. For this reason, international law before this time was not concerned with giving children a special and independent right in international and non-international armed conflicts, because they are covered by the rights granted to a larger description, that means under the term of civilians. The central question that whether the provisions of the additional protocols are still effective in limiting grave violations against children, have the statute of the ICC contributed to an implicit update of these provisions. In this lecture, there are general and special rules for protecting children from the from the effects of armed conflicts will be discussed with reference to the provisions of additional protocols in particular. I mean, 2 additional protocols. The protection of children under the term of civilians was and still is a center of international concern because it is simply not possible to accept that children are included as part of an armed conflict. And the parties of the conflict must abide by that also, and because children fall within the civilian community, IHL establishes general and other special rules, which we'll try to discuss it as follows. We can add something, not just IHL will cover the protection of children. There are international instruments also regulate the protection for children like human rights law. We'll return to general rules of IHL. In this part, we will discuss the principle of distinction between civilians and combatants, the principle of proportionality, and the use of force. The principle of distinction between civilians and combatants is considered a recognized principle in customary rules of IHL. Before it was treaty-based, and this principle gained recognition in the 18th century as the war rivalry is no longer directed against civilians. At the legal level, this principle was not explicitly codified except in Article 48 of the First Additional Protocol of 1977, which obligates the conflict parties to direct military operations against military targets only. Emphasizing this, paragraph 2 of Article 51 of the same protocol indicates that it is not permitted that civilians be the object of attack, nor a basis for spreading terror among them. As for the principle of proportionality and the use of force, paragraph 5/B of Article 51 of the First Additional Protocol requires the conflict parties to study the effects of armed conflicts and whether it is expected to cause civilian loss by killing or to inflict injury to them, to a degree that exceeds the direct military consequences of hostilities. This is also confirmed by paragraph 2/B of Article 57 of the protocol itself, whereby obligates the parties in a conflict to cancel or suspend any attack against civilians or civilian objects directly or indirectly that outweighs the definite military advantage of that attack. In the light of what mentioned before, it becomes clear that the IHL establishes general principles for the protection of civilians from the effects of armed conflicts in which the children are an integral part of them. A question here arises, despite the civilians in general are protected according to this principle, but is it not the children given exceptional protection? To answer this question, it is necessary to conduct a thorough study of what the current statute of armed conflicts turns to, and by that we mean the use of children as a human shield, either by coercion or voluntary. One of the most distinctive features of the current armed conflicts is the transfer of their scope from the original parties to the conflict, that's mean belligerent forces, to outside their legal framework. They are civilians, which can now be observed in what is known as a human shield that we can define as the deliberate use by a party in an armed conflict of civilians, whether they are subordinate to it or to their enemy's nationality, and placing them in places separating the belligerents forces, and the aim of that is to deter any counterattack. And this case, the civilians are described as hostiles for military purposes. Well, IHL imposes a provision obligating the defending party to avoid civilians from the targeted military sites, as well as prohibiting their use as a human shield by avoiding the establishment of military targets in or near densely populated areas. This provision is based on jus in bello, and its violation means committing a war crime. And based on this provision of Article 58 of the first additional protocol, and in terms of the provisions of paragraph 23/B of Article 8 of the Statute of the ICC. The use of children as human shields, even voluntarily, does not mean that it is legally, as children's lack of legal capacity negates the voluntary nature of protecting a military target. This is general principles or general rules, while the special rules, before looking into the special rules for protecting children, it is necessary first to explain the source of these rules, when and where they are applied, and the obstacle that prevents their application in case of conflict with the general rules. During research in applicable provisions, we found that the IHL refers to the special rights for children in wartime, including what the 4th Geneva Convention of 1949 affirms. In Article 24, regarding obligating the conflict parties to take the necessary measures to ensure that children who are orphaned or separated from their families are not neglected. In this regard, Article 50 of the same convention refers to the duties of the occupying power to operate the facilities designed for the care of children. Among the issue that can be considered in what Article 132 of the 4th Geneva Convention itself refers to, by calling the conflict parties to conclude agreement during the conduct of hostilities to release certain categories of detainees or to return them to a neutral country, especially children and their mothers. This is we found at present in the agreements that take, for example, that take place between the armed groups and regular armed forces, and negotiating about the removal of civilians from areas of armed conflict, as what happened in Syria in 2014, to expel the civilians from the Al Yarmouk camp to areas far from armed clashes. When we return to the 2 additional protocols, we find the first additional protocol regulates specific issues, including what is stated in paragraph 4 of Article 77, which obligates the conflict parties to place children in case of arrest or detention in places separate from those designed for adults, while paragraph 1 of Article 78 of the protocol itself refers to obligating the parties in conflict to take the necessary measures to prevent the evacuation of children without their nationals to foreign country, or for compelling reasons related to the child's health interest. The application of IHL at the present time becomes closer to application and synchronization with the human rights law during the international and non-international armed conflicts, and this is what international practices are settled about. The inevitable effect that can be reached is that children, whether they are recruits or victims of attacks against civilians, are permanently victims of two types of effects. For a recreated child, the value of others' lives and the future weakness, and nothing will deter him or her from committing crimes, even if they are against his or their society. As for the children who are victims of the effects of armed conflicts and by what we can survive of death, the effects of that horror will remain in their minds, and in both cases, it is considered a crime against childhood, and the right to protection is rooted both in international humanitarian law and human rights law. We have discussed general and specific rules for the protection of civilians in general and children, especially in times of armed conflict. We have to ask, would a violation of these rules to be equal in relative gravity? To describe the most serious violations? I think this is very important questions, and I advise my students, if they're available in this lecture, to prepare studies, deep studies about this issue. To answer, we say that the type of target group should be taken into account, as well as the type and gravity of prohibited behavior. For example, in the first additional protocol, and although the rules of protection for civilians are of priority, but the article, for example, Article 70 of the same protocol gave greater priority in particular to children. For example, the first paragraph of Article 70 indicated that priority is given to the disruption of relief consignment to those persons such as children and those who are parents to receive favorable treatment or special protection. While Article 4 of the second additional protocol consider the requirement of children to be a prohibited behavior, it appears from the foregoing that the prohibited behavior has been carefully chosen and two additional, but according to each case in which the behavior is committed or so-called circumstantial prohibited behavior. Child recruitment was chosen as the most dangerous type, for example, and especially in second additional protocol, as it is associated with the specific harms to child soldier. In other words, not every conflict will cause suffering with the same cruelty. The psychological and physical effects of the recruitment of children are more severe than forcing an adult civilian to engage in hostile operations. For example, the Office of the Prosecutor of the ICC goes to the fact that the identity of the victims can influence the determination of the severity and relative gravity of the prohibited behavior. For example, it will be more dangerous when directed against women, children, or patients. Through the foregoing, the case of violation of the rules of law related to the protection of children will be more serious than that of the rest of the other protected groups, and therefore the assertion of protection must be strict and does not accept any justification when attributing to the individual criminal responsibility. Our recent study, for example, indicates that in past 3 decades, the number of children living in areas of armed conflicts had tripled, and the number of children at risk of recruitment into armed conflicts has tripled from 99 million in 1990 to 337 million in 2020. Approximately more than 1 billion children live in 39 countries, with one or more actors in many armed conflicts reported to be involved in child recruitment. By reviewing the international conventions concerned with the limiting the effects of armed conflicts, especially against children, we found that before the adoption, it's clear that there is no reference to allocating rules for the protection of children, except in some provisions, such as the prohibition of recruitment, as in Article 50 and 51. And when reading paragraph 2 of Article 50, we note that this clause perhaps the occupying power from recruiting children in its military units or in its organizations of a military nature. In order to remedy this shortcoming, the two additional protocols of 1977 addressed the shortcoming of the four Geneva Conventions in prohibiting the recruitment of children by narrowing this legal gap. For example, paragraph 2 of Article 77 of the first additional protocol refers to a number of obligations imposed on the parties to the conflict, such as not to involve children under the age of 15 years in direct hostilities. Made the criticism of the above above paragraph as embodied in its ineffective legal content, because it allowed the parties to the conflict to avoid any accountability for the violations. Especially, I criticize the phrase by take all possible measures. That is flexible and interpretable, which helps the parties to the conflict with impunity. What was said previously regarding international armed conflicts? What is the ruling on the recruitment of children in non-international armed conflicts? To answer this question, we review paragraph 2/c of Article 4 of the second additional protocol, which prohibits the recruitment of children. This paragraph prohibits the recruitment of children under the age of 15 years, whether they are in the regular forces or armed groups, and whether they participate in direct combat operations or in acts of combative nature. A comparison between the provisions of paragraph 3 of Article 77 of the first additional protocol makes it clear that the former paragraph is more obligatory in that it does not refer to possible precautions, but there is no absolute obligation by which the paragraph starts. It is not permitted. And this makes violating of the provisions of the second additional protocol. On the other side, paragraph 3 of Article 4 of the second additional protocol formulates a similar provisions through emphasizing a special protection of children soldiers when they fall into the hand of the enemy. The recruitment of children as soldiers in armed conflicts in general will mean that its effects will not be limited to direct or indirect participation in hostile operations, but rather that this grave violation has other reflection, as the emergence of children in the midst of armed conflicts and use there as a part in war, it will mean preparing for a generation that does not recognize peace or security, and thus moving to another source of instability in societies after the end of thus armed conflicts. As the sense of violence will remain in the memory of children, and they will not accept a level other than violence among their peers of children or the environment in which they live. The prohibition and the two additional protocols has a legal aspect, or has a logical aspect, as the drafters of the provisions of these two protocols did not consider the direct effects of armed conflicts on children, but rather to the aftermath of the conflict itself. And the evidence is that most of the areas that witness grave violations against children did not witness stability even after the end of the armed conflict, simply because thus atrocities led to a widespread involvement of adult and armed groups who were originally children who lived in the midst of armed conflict. With regard to this part of this lecture, children and their related basic needs, such as infrastructure or education, the legal framework that protects children's right to education has been emphasized in many international instruments. For example, Article 77 in paragraph 1 of the first additional protocol, and in Article 4, paragraph 3A of the second additional protocol, as well as Article 94 of the Geneva Convention of 1949. In order to approach the issue of violation of children's right to education and the effects of this violation, it can be said the violation of the right to education can take in several methods, including mainly targeting and destroying schools during hostilities, or by using them for military purposes, or threatening teachers, and therefore all of these methods will either destroy or disrupt the role of schools and education, which leads to the prevention of children's refusal to learn, and from here the armed groups will begin to recruit children voluntarily or even forcibly. This will constitute the first of the 6 grave violations, in other words, engage of children as recruits. Among the other violations accompanying the prevention of children from education is the correlation to work in illegal and inhuman conditions, the most important of which sexual slavery or even sexual violence, especially against girls. And it's possible that these violations lead to the habituation of children. These are practices that constitute a violation of the child's rights to life and health, even after the end of hostilities and the return of schools to normal. I will transfer my lecture to another side, I mean, from protection to criminal accountability, and two additional protocols, a contribution on this side. Firstly, we have some questions like, how do the two protocols protect children? What is the criminal aspect when a violation occurs? Did the two protocols adopt the concept of relative gravity when codifying the prohibited behavior? In this regard, it can be said that two protocols dealt with the situation of children in terms of armed conflict at different levels, as the drafters of the texts tried to focus on specific aspects and in different ways. First, by the prohibition of direct, for example, prohibition of direct targeting and the term of civilians, and then moved to implicit prohibition. For example, the second additional protocol explicitly referred to the gravity of violations that children may be exposed to by mentioning a number of prohibition acts that reflected two things. The first of which is the non-repetition of the atrocities committed during the Second World War, and the secondly is essential by mentioning the most serious prohibitions, as in Article, for example, as in Article 4 and Article 6 of the protocol, and that these provisions have become among the rules that the parties to the conflict cannot argue for not recognizing them, as they are customary rules that are binding on all and in all circumstances. So, what is the position of ICC on the violations that took place against children? How can I prove the relative gravity? I mean, make comparison between two additional protocol and the statute of ICC. The ICC has the most complex relationship with the relative gravity. For example, the preamble of the Rome Statute describes the raison d'etre of the ICC as being derived from the conviction that grave crimes that threaten the peace, security, and welfare of the world, and thus entail a special punishment. Ideally, in the preamble of Rome Statute, the signatories agreed that the most serious crimes of concern to the international community as a whole should not go unpunished, as well as in Article 1 of the Statute of ICC, when it referred to the jurisdiction of the court over the most serious crimes. The principle of relative gravity appears on two levels on the ICC. First, the Rome Statute grants the International Criminal Court jurisdiction over the most serious crimes of international concern. Secondly, it defines that following grave crimes: genocide, crimes against humanity, war crimes, and the crime of aggression, even if the conduct falls within the legal definition of one of these enumerated crimes, it allows the ICC to declare a case indemnifiable if it is not of an educated degree of gravity. The crime can be classified as one of the serious crimes listed in the statute, but it is not serious enough to justify international punishment. For the ICC to penalize crime, it must present certain features that make it particularly dangerous. The drafters of this Rome Statute attempted to emphasize the threshold of relative gravity out of the concern that the ICC will become overburdened if it is substantive jurisdiction too broad. The ICC instead focuses only on crimes considered the worst of the worst. The relative gravity within the framework of the rules of international criminal law has a special and distinctive appearance to the extent that it is described as behind the existence of this law. The effect of the relative gravity become clear by linking it to the formation of criminal courts and determining their jurisdiction. In this sense, that all international criminal bodies were formed either because of the occurrence of international crimes that have high gravity, which applies to all temporary tribunals, or to confront serious crimes that may be committed in the future, which applies to the ICC. From this, it is understood that the relative gravity of crimes has a direct impact on the establishment of international criminal court. On the other hand, the relative gravity of crimes has an impact on determining the jurisdiction of international criminal bodies. For example, the ICC granted jurisdiction over persons for the most serious crimes of international concern. Therefore, the basic provisions identify the most serious of crimes to include genocide, crimes against humanity, war crimes, and other the crimes of aggression. The application of the legal definition of these crimes to a specific behavior is not sufficient for the jurisdiction of the court, but rather the behavior must reach a certain gravity, as we mentioned earlier, like in Article 17, paragraph 1 of the Rome Statute, sets a basic and general condition that applies to all crimes in order to accept any case before the court, which is that the crime be of a sufficient degree of seriousness. Declaration of the relative gravity has an important effect for starting investigations in many situations or case by the public prosecutor office. In general, the public prosecutor relied on a set of criteria to determine the relative gravity of any act as a condition for starting an investigation, including, for example, the size and seriousness of crimes, the systematic nature of them, the way they were committed, their impact on the victims. Maybe I will reach the final paragraph of my lecture. I'm focusing on the contribution of 2 additional protocols and the rules for protection children in times of armed conflicts. Maybe I can say the drafters of 2 additional protocols, they was very smart because they cover the headlines of rules of protection and open the door for the next updates. I mean, ICRC make update studies from time to time to interpret the articles of 2 additional protocols, and also I'm saying that the 2 additional protocols codifying the headlines or the primarily rules, while that's not mean there are no updates implicitly. I mean, maybe we can touch this in ICC statute, and we find there are many acts, maybe more than the acts which are contained by 2 additional protocols. Thank you very much, Simona. Did you hear me?
Thank you very much, Professor. I just want to see if we have some question in the chat. Doesn't seem. So please, if you have questions, raise your hands, participate, or write it in the chat. Let's wait if they have any questions.
I can complete if there is no.
Okay, yes, we have. Do you want me to read it, or? Thank you, Professor, for the presentation. Why the 2 additional protocols for the GCs focused on specific types of bannings? If you want to read it, you can also. And these bannings conclusive or as examples?
Okay. Can I answer or?
Yeah, you can. Thank you.
Okay, thank you very much. I think this is a smart question. Can you repeat the question?
You can read it in the chat if you prefer. Okay. I can read it.
Okay.
No, maybe it's for you, it's my English. Why the 2 additional protocols for the GCs focused on specific types of bannings? Are these bannings conclusive or as examples?
Okay, thank you very much.
Okay.
I think it's a critical question. I think this is searching by many academic circles about this question. They reached a final important question is whether the prohibitions and the additional protocol will be strictly adhered to by the ICC, or whether the prosecutor has the authority or to initiate or accept the attribution of responsibility in the event of committing dangerous behavior. The prohibitions or bans in 2 additional protocols, it is like I'm said in before, it is primary lines. That's not mean there is no any kinds of acts, or I mean illegal acts. The prohibitions in the additional protocols are clearly the main line threshold, jurisdiction, and admissibility. Then yes, a broader jurisdiction can be undertaken in this respect. The evidence for this is that the breakdown of the crimes mentioned in the statute of ICC, it was more comprehensive than in the 2 additional protocols of 1977. When we see the 4 crimes in statute of ICC, we will find more and wider picture for a wider illegal act. I think this is a proof that the 2 additional protocols, when mentioned bans or prohibitions, it's put the primary banning or primary prohibitions.
Yes, I'm just seeing if we have other questions. So please don't be shy to raise your hands. We can give you the possibility to speak with Professor Ahmed.
Maybe there's another critical. The second additional protocol has to the respects the principle of truthfulness. There's another question.
Sorry, no, I can't see any other question.
Okay, maybe there's another critical issues dealing with the children when they involved in armed conflicts. Also, I'm advise my students, my colleagues, the participations in this course to rethink about this issue. I mean, the criminality of children when they commit crimes in armed conflicts, and the age of accountability. This is an issue I think it's very important to focus on, because back ICC have no jurisdiction over crimes committed by person under 18 years. The recent studies maybe make some new ideas. So what about the victims of of armed conflicts? I think this is also maybe we have 2 aspects of children. One as a victim, was another one as a murderer. We should to fix this issue, like what the National Criminal Domestic relating this issue by prepare courts or prepare places for juvenile. I think this is also an important issue. Should be shed light on it.
Perfect. Thank you so much. I can see a raised hand. Sanarta. I want to see if she or he has a question. Sanar, can you hear us?
Yes, good evening. I just wrote the question on the bar questions. It's actually related to the second additional protocol to the Geneva Conventions. By drafting it, it respects the principle of territoriality and non-intervention in the internal issues of other states. How do you see this in relation to universal jurisdiction related to violations of international humanitarian law and international criminal law? Thank you.
Thank you, Sanal. This is excellent question. When returned to 1977 and search about the negotiation process and the ideas of negotiators, I'm sure they're not thinking about what will happen in the last or next decades. Absolutely, the situation of when they adopt the especially the second additional protocol, they hesitate to not open the door for intervention. For this reason, they very carefully to not open this issue and put this article. But after the decades and the international criminal law face a dramatic change from sovereignty and transfer to global jurisdiction. This is maybe it's overlap between two issues, but at least I think the humanity will be victory in this overlap. I mean, when we have a conflict between sovereignty and protection like children, absolutely the protection of children rules will be more respect than sovereignty when the state do not respect the protection of children or protection of civilians in times of armed conflicts. This sense, I think, just like conflicts between two rules, maybe discussions. The first one, the sovereignty, immunity, and the other one, the protection of human in times of armed conflicts. When they conflict themselves, I'm sure the protection rules, I mean, protection of children in times of armed conflict will be priority than the sovereignty. And I'm sure when returned to 1977 or returned to negotiate on this article, I think it will be more difficult to think about the global jurisdiction than now.
Perfect. We thank you so much, Professor Al-Fatlawi. I don't know if there are other questions. We can give another minute to see if you have any other question, or we can if there are not any other questions, of course, you can, I remind you to also to ask us questions through our email, the email which you receive, with you receive the link if you have questions on the lectures. And I see Dr. Massidda, Mrs. Massidda. If there are no other questions, I can say that we can see us tomorrow at 2 o'clock. We thank all the professors, all the lecturers, Professor Al-Fatlawi, Professor Capone, Professor Massandrea Bonaviri, and we will send the link tonight. I can see sometimes you send us emails. We normally send the link of the webinar the late evening, night before. Okay. Thank you. Thank you so much to everyone. Thank you.
Thank you so much. Thank you. Bye-bye. Thank you.
Bye.